Good morning, everyone, and welcome to today's employment law webinar. My name is Marty Rabinovitch. I am a partner at Devry Smith Frank, and I head up the firm's employment law group. And speaking with me today is my colleague, Leslie Haddock, who also practices with me in employment law. For the human resources professionals in attendance today, the program has been approved for CPD hours. We will be sending you the code after the presentation for you to claim those hours. If you don't receive the code for any reason within 24 hours, please contact us and we will make sure that you have that code. And for the lawyers in attendance today, the program has been approved for 1.5 hours of CPD content with the Law Society of Ontario. Here is an overview of today's presentation. I will start off very shortly with the termination clauses update section. So that will be an overview of some of the very important and most recent decisions about the enforceability of termination clauses. And after that, Leslie will take over and she will present the case law update section, which will include summaries of a number of recent cases that do not have anything to do with termination provisions, to give you a break from that. And then Leslie will continue with our section on recent amendments to the Human Rights Tribunal of Ontario procedure and to the ESA, the Employment Standards Act. I will then present the section about what employers can expect in 2026 in the world of employment law. We will then take a 10-minute break. We will come back for a Q&A period, and then we will conclude the seminar, which will be finished by 11:30. On the topic of questions and answers, please feel free to submit any questions that you may have throughout the presentation through the Ask a Question feature in Zoom webinar. We will answer as many questions as we can throughout the presentation in writing through Zoom. We will address some of your questions orally during the Q&A period, so we'll get to as many as we can. If you think of any questions after the presentation, or if for any reason we aren't able to address your question, feel free to contact either Leslie or me, and we will address your question at a later time. So let's get right into it. We will proceed now with our section on the case law about termination clauses. So when we're talking about the cases about termination clauses, the issue that we're dealing with is, when should a termination clause be enforced by the courts? When should a termination clause not be enforceable? Typically, what we see is that employers have contracts with termination clauses which seek to either limit an employee's entitlement to only the minimum entitlements under the Employment Standards Act and to avoid paying a common law reasonable notice period, which in most cases would be substantially greater. And at a very high level, the reason why a court may find a termination provision to be unenforceable is because the provision seeks to provide the employee with a lesser right or benefit than what the ESA would provide. Okay? So let's start by reviewing the decision of Wood and Fred Dealey Imports. It was decided back in 2017 by the Ontario Court of Appeal, which, by the way, is the highest court in Ontario. So some of the principles that come from the Wood and Fred Dealey decision is that a termination clause as drafted must comply with the Employment Standards Act, and the employer's subsequent compliance with the ESA would not cure an otherwise enforceable provision. So, for instance, if the employer has a termination clause which for instance does not say that the employee would be entitled to benefit continuation, and then terminates the employee without cause and continues the benefits anyway for the ESA notice period as they would be required to do, the court will essentially say, well, that's nice, but it still doesn't change the fact that your termination provision is going to be unenforceable. Okay, so put a little bit differently, the courts are to assess the contract itself and not whether the employer's actions on termination complied with the ESA when we are determining enforceability. Okay. As well, given the power imbalance in employment relationships, the courts have held that any ambiguity in termination provisions is generally going to be interpreted in favor of the employee. And we know from Wood that the courts are going to strictly scrutinize termination provisions. The court's starting point is they generally don't like it when the employers have this language that is trying to take away a common law entitlement to the employees, so they will scrutinize these clauses strictly. And the other thing is that if you have a termination provision that potentially might not comply with the ESA, it's going to be void. So, for instance, if the employer has a clause which says, well, if we terminate you without cause, we are going to, give you 2 months of notice and 2 months of benefit continuation, and that's, going to be it, right? But if it turns out that the employment relationship, lasts for 20 years and there's going to be an entitlement to ESA severance pay, that clause now has the potential not to be enforceable at a later date, and the courts have held that it's not going to be enforceable now either. Okay, let's move along to the decision of Waxdale and Swagan North America Inc. That was a big one that was decided in 2020 by the Court of Appeal. What do we take from this case? Well, the court made it very clear that termination clauses, or in other words, any provisions that relate to the employee's entitlement on termination, must be read together as a whole. And if any part of the termination scheme violates the ESA, then the entire termination scheme is void. As well, the location in the contract, or which section these termination clauses are located in the contract, is irrelevant. The courts are going to assess the substance. The courts are going to look at what does the contract actually say, to determine what's part of the termination scheme and what's not. And if there is a problem with any portion of the termination scheme, then that provision will be unenforceable. And one of the cases that Leslie will talk about a little bit later on is actually about whether a temporary layoff provision should be considered part of the termination scheme for this purpose. And so Leslie will get into that a little bit later on. And then we have the decision of Dufo and the Corporation of the Township of Ignis, decided at the trial level in 2024, also affirmed by the Court of Appeal later that year in 2024. And this is where the court struck down a termination clause as unenforceable because it included language which stated that the employer was permitted to terminate the employee without cause at any time, and in its sole discretion. And the court found that this was problematic. Again, going back to why would a termination provision be unenforceable? It's because it seeks to give the employee a lesser right or benefit than what the ESA would provide for. So the court's rationale was that this at any time language with respect to termination um, was in fact seeking to provide the employee with less than the ESA because it suggested that the employee could, for instance, terminate an employee during a job protected leave under the ESA. Okay. Now, just to highlight, we'll get to this in a bit more detail. There was another decision called Lee and Wayfair Canada, which where the court arrived at a different conclusion, despite the fact that there was similar language. So there is a little bit of ambiguity on that point right now. But as a general drafting principle, generally we should be avoiding this at any time and sole discretion language in the context of termination provisions. And then the Dufo decision was upheld on appeal. The Court of Appeal actually did not address this at any time issue. The appeal was what was upheld for other reasons. But what that still means, though, is that the Superior Court decision what was unchanged, so it still remains good law. Okay. Let's now get into some 2025 decisions about termination clauses. So the first case from 2025 that we'll look at is called Baker and Van Dolder's Home Team, Inc. So as a starting point, there were termination provisions. There was a resignation provision, a without cause termination, a with cause termination provision. The employee does get terminated for cause. The issue is whether or not the termination provision should be enforceable. Um, there was there were two parts to the termination clause, as you see here on this side. There was a termination without cause slide, or sorry, termination without cause provision, and a termination with cause provision. Okay, I'm going to focus on the without cause provision here because that's perhaps what's new here, perhaps most important here. So we see here that in this without cause provision, the employer did have language saying that they could terminate at any time. Okay, so this slide summarizes the employee and the employer's argument on the issue. So the employee, for instance, argued essentially that the without cause provision, um, you know, misstated the ESA or provided for a lesser benefit in the ESA by granting the employer the right to terminate at any time. And the employer tried to distinguish that and also cited another case here called Bertsch, which we will get into. Okay. Ultimately, the court finds that the termination provision is unenforceable. And again, what we will focus on here is again the without cause provision. So what you need to know really is that Baker is an example of a decision which applied the court's reasoning in Dufo with respect to this without cause and at any time language with respect to termination. Okay. And here's a summary of what we can take from this case. Basically, just be careful and watch out for this at any time language in the drafting. Let's look at Bertsch and Datastealth Inc. 2025 Court of Appeal. This is actually a very, very important case and a good one for employers to take note of because in this one, not a spoiler alert here, the employer won. The termination provision was found to be enforceable by the Court of Appeal, which is again the highest court in Ontario. And it takes a lot, for the Court of Appeal to overturn itself. So in other words, it's probably not happening anytime soon. So in this case, the employee, Mr. Bertsch, was a vice president. He was not employed for very long. It was only about 8.5 months. He sues for wrongful dismissal. And the issue is essentially he's saying he should be entitled to a common law notice period rather than the uh, the 4 weeks of pay that he received, which, by the way, did exceed his ESA entitlements, but he's clearly seeking for a longer common law notice period. So this is the termination provision in question here. Okay. Keep this slide handy. Make a note of it because, again, spoiler alert, the employer won. This clause was found to be enforceable. Why did the court decide that this clause should be enforceable? So one of the employees' arguments was that the clause was ambiguous. Okay. But the court made it clear in Bertsch, first of all, that no, the court did not believe that the clause was ambiguous. But the court notes that ambiguity requires more than just a competing interpretation. That the clause in question must genuinely be capable of more than one reasonable interpretation. So put a little bit differently, the courts must ask how the agreement can reasonably be interpreted and not how an employee who is uninformed about the ESA might misinterpret it. Okay, so just because there's some possible other way to interpret the provision, that doesn't mean it's ambiguous. There has to be reasonable competing interpretations, or else the court is not going to find that a termination provision is ambiguous. And the court also concluded that the words with or without cause in the provision were clear. The clause explicitly granted ESA minimum entitlements to the employee, and there was no intention to contract out of the ESA. Okay, so what do we take from Bertsch? We got the lessons about ambiguity. Okay, and it's very, very important to draft clearly when we're doing termination clauses. And if the language is clear, the court is not going to search, for ambiguities where none exist. And there's actually an older case called Amberberg where the court addresses ambiguity like that as well. Okay, so what can we learn from this as well? Well, first of all, I mean, this case actually shows us that, believe it or not, it is possible to draft an enforceable termination provision, which limits employees to only their statutory minimums. Okay, so take note. Um, all right, I want to address one more case in this section. Or actually, there's two more. Sorry, there's Lee and there's one more. So Lee was the case that I referred to a little bit earlier, and I commented that the conclusion in Lee was different from Dufo despite there being similar language. So this slide contains a summary of the facts. It's similar in that it's a termination without cause, wrongful dismissal, and the dispute is about whether a common law notice period should be awarded on the basis that a termination provision was unenforceable. So here's a summary of what was included in the termination provision. So there was actually a with cause provision here, which says the employer could terminate at any time for cause without notice unless expressly required by the ESA. So we see here that there is this at any time language here. Okay, the contract also had a definition of cause. And then in the definition of cause, they essentially used the ESA definition, or the regulation definition, regulation 28801, the willful misconduct definition. Okay, and then there was a without cause provision which said that termination would be permitted at any time and for any reason. Okay, so far it's looking like it's pretty similar to DUFO, and that the decision, if we're going to go along with DUFO, should be that this provision is unenforceable. Okay, and this slide summarizes the positions that both parties took. But in this case, the trial judge actually deviated, I would say, a little bit from DUFO, and found that the termination clause was enforceable. And essentially, the judge said, look, when everything is read together, there are no, ESA breaches. And here, this is particularly interesting for the without cause provision. The court concluded that although there was this, you know, phrase, that the suggesting that the employer could terminate the employee at any time and for any reason, he says the clause was saved by repeated references to ESA compliance. The specific inclusion of ESA entitlements, including termination pay, severance pay, and benefits, distinguished the case from DUFO. Interesting. Now, the case is under appeal. Okay, so it will get heard by the Court of Appeal at some point, and may be overturned. But for now, I mean, if we're looking at this from an employer's perspective, I mean, this case, along with Bertsch, would be good cases to rely on to defend an employee's argument that a termination clause should be unenforceable because of the at any time language. And the last case in this section is called Chan and NYX. I mean, really, it's a similar facts. It's the enforceability of a termination clause. We got a without cause termination provision, which is saying that the termination could occur at any time. And the purpose really of including this case is that it's another example of the court following DUFO. Okay, so because there was this at any time language, the termination clause was found to be unenforceable. Okay. So we will summarize quickly here the current state of the law on termination clauses. So a termination clause should be clear and unambiguous when interpreted reasonably. Any ambiguity is generally going to be interpreted in the employee's favor, despite, what we're seeing, in some of the cases, or at least the one case. You should avoid the at any time and for any reason language. Okay. It's important for termination provisions to explicitly state that employees will receive their minimum statutory entitlements under the ESA and its regulations. And again, don't forget about Bertsch. This is an example of a termination provision that was upheld by the Court of Appeal, and we've included this clause again for you just to emphasize its importance. Okay, so that concludes this presentation, and I am now going to pass things along to Leslie, who will present the case law update topic, which will involve cases that now have nothing to do with termination clauses, to change gears. So Leslie, all yours.
Right. Thank you, Marty. All right. So the first case that we are going to talk about today, or not related to termination clauses, is Taylor and Salytics. So in this case, the employee was employed for approximately 11 years and had an employment contract that included a with and without cause provision, as well as a temporary layoff provision. So in February 2024, unfortunately, the employer began experiencing financial difficulties, and the employee agreed to a 20% reduction in hours and pay to avoid being laid off. Nevertheless, unfortunately, in April, Taylor, the employee, was placed on a temporary layoff. On July 19th, he commenced an application and argued that the temporary layoff constituted a constructive dismissal. Right. And then in June and July 2024, the employer began to recall some of the employees, and ultimately Taylor himself was recalled on September 30th and began working at the company again full-time. So the key issue here is, would an unenforceable termination scheme also render the temporary layoff provision unenforceable? So the employee took the position that the layoff provision was under the termination heading of the employment contract. And as well, a layoff is a constructive dismissal, as well as a termination at common law. Therefore, the temporary layoff provision was part of the termination provision. And as Marty mentioned, if one part of the termination provision is unenforceable, the entire part is unenforceable. And in this case, both the employee and employer agreed that the for-cause termination clause was unenforceable. Therefore, he argued that the entire thing should be unenforceable and he should be entitled to common law note or reasonable notice. However, the employer took the position that the temporary layoffs were expressly permitted by the employment contract, as well as permitted under the ESA. And as well, the placement of the layoff provision underneath the termination heading in the contract was irrelevant. And again, the ESA, temporary layoffs are not a termination if they fall within statutory limits. And therefore, they argue that he was not constructively dismissed. So the court took the employer's side on this. They agreed that in this case, the temporary layoff provision was not part of the termination clause, just because it was located under the termination subheading didn't automatically make it part of the termination clause. And again, a layoff provision or a layoff will only amount to constructive dismissal if there's no contractual authority to impose it and it doesn't comply with the ESA. But in this case, it was expressly permitted in the contract and complied with the ESA, so it was not a constructive dismissal, and Taylor was not successful in his claim. So what does this case mean for employers is that a temporary layoff provision is not a termination provision. The location of a clause does not determine its nature, and courts will look to the substance of a clause rather than just its form. And again, layoffs will not constitute constructive dismissals if they are permitted by the contract and comply with ESA. However, if the contract does not have an enforceable layoff provision, a temporary layoff will constitute a constructive dismissal and the employee will then be entitled to reasonable notice. So very important to make sure your contracts include those clauses. Right, the next case that we are going to go on to is Boyer and Calidus Capital Corporation. So in this case, the employee was an executive underwriter and he had an oral employment contract. He announced that he was planning to retire in December 2016, but ended up leaving earlier in September, claiming that the workplace had become toxic and that this was a constructive dismissal. So he sued on the grounds that it was a constructive dismissal, claiming reasonable notice, as well as seeking benefits, including unpaid vacation pay, deferred bonuses, and the value of lost stock options. The employer argued that the employee resigned and also counterclaimed for $150 million in damages and alleged that he mismanaged 3 major loans. So the counterclaim ended up being dismissed in 2023 and the Court of Appeal noted that the damages claim was essentially baseless. So the main issues for this case is, was the employee constructively dismissed? Is he entitled to the bonus or the benefits? And can the employer rely on this allegation of cause even though their counterclaim was dismissed? So the employee took the position that he was constructively dismissed prior to his planned retirement, and he was entitled to the benefits. He said that the employer's claim that he was not entitled to the benefits on the ground of policies, including in terms of vacation pay, a use it or lose it vacation policy, as well as modifications to the deferred bonuses and stock option plans, which limited his entitlements to these benefits during his retirement. He also claimed that they could not rely on just cause allegations that he mismanaged loans, as the counterclaim was dismissed already. So the employer said that he voluntarily retired and was not dismissed. They claim that he engaged in misconduct, which justified dismissal for cause and disentitled him to the bonuses and stock options. And they also claimed that they were entitled to rely on the misconduct, and the just cause allegation should be considered completely distinct from the counterclaim. All right, so ultimately, the court decided that the employee was not, in fact, constructively dismissed, but nevertheless, he was still entitled to the benefits that he claimed. So this was a very substantial payout. So it was $93,000 and change in unpaid vacation pay, $525,000 in unpaid and deferred bonuses, and $1.21 million for lost stock options. They noted that the statutory rights to vacation pay under Section 38 of the ESA cannot be defeated just because the employer alleges just cause. And as well, the employer failed to provide evidence that the employee was aware of the policy changes, which allegedly disentitled him to these benefits. And they couldn't prove that he had actually agreed to them. And again, as the employer had already relied on just cause in the counterclaim that was dismissed, it couldn't rely on just cause again and raise the same factual allegations in this claim. And then the employee was granted a substantial cost award as he was successful. All right, so some key takeaways from this decision is that employers should ensure that the employees are notified of and agree to important policy changes and changes to their employment, particularly if they relate to the employee's compensation and benefits. Additionally, retired employees remain entitled to contractual benefits, absent clear evidence that the rights were validly limited by the employment contract. And again, as this employee had an oral contract, it shows that contractual rights are enforceable even when there's not a written agreement and it's just an oral contract. Right, so the next case that we're going to look at is McFarland and King Ursa Incorporated. So in this case, the employee was an executive who had a salary of $300,000. In July 2022, the employee went on maternity leave, and unfortunately, during her absence, the company faced some financial losses and setbacks, and to help offset these losses, asked her 2 times to extend her maternity leave, to reduce their payroll costs. So in April 2023, shortly before she was scheduled to return, she was presented with a letter and a proposed agreement to reduce her salary to $210,000, so reduce it by approximately $90,000 or a third, and demote her back to her previous position, which was lower. The employee rejected the new agreement. She resigned and filed a claim for constructive dismissal as well as discrimination. So there's quite a few issues in this case. We are going to mainly focus on whether the letter constitutes constructive dismissal by imposing a demotion and salary reduction, whether or not there was discrimination under the Ontario Human Rights Code, and whether or not punitive and moral damages should be awarded. And just so punitive and moral damages, those are moral damages in particular are intended to compensate the employee for intangible harm, such as humiliation and damage to self-worth. And those damages are based on the harm to the employee themselves, whereas punitive damages are non-compensatory and intended to punish the employer for malicious, oppressive, and high-handed conduct, and try to deter them from that misconduct in the future. Right. So the employee took the position that her demotion and reduction in salary were a unilateral change to the fundamental terms of her employment, and therefore she was constructively dismissed. She also claimed that the employer's actions were discriminatory as they were based on her gender and family status, and they warranted punitive and moral damages. The employer argued that it was not a constructive dismissal, but instead it was a legitimate adjustment to her employment based on the company's poor financial performance. So demotion was not, they also said the demotion was not intentional and arose from a template error, and the pay reduction was consistent with cuts that her other colleagues in a similar position had accepted. They also said that she failed to mitigate her damages, and as well maintained that the discrimination claim was completely unfounded as the changes were solely motivated by financial necessity and not her gender or her family status. Ultimately, the court found that the letter did constitute constructive dismissal, as both demotion and a significant salary reduction individually would likely constitute constructive dismissal in most cases. The court also rejected the employer's mitigation defense, found no evidence that the employee failed to pursue comparable work. And they ultimately dismissed her discrimination claim, as they concluded that there was no evidence to show a causal connection between her gender and her family status and the company's ultimate actions in reducing her pay and demoting her. However, they did award $40,000 in moral damages because they found that the demotion was insensitive and harmed her professional identity. So some takeaways from this decision are that, I guess it affirmed that a demotion and substantial salary reduction will almost always constitute constructive dismissal. Also noted that courts are willing to award moral damages even without evidence that the employer was actively malicious. It's again just focused on the impact of the employer's actions on the employee, not the intentions of the employer themselves. So employers should exercise a lot of care when communicating changes to the essential terms of an employee's position, particularly when the employee is in a vulnerable position, such as when they're returning from a protective leave. And if employees are alleging discrimination, there's also a requirement to prove that there is, again, a causal connection between the protected ground that they are alleging as well as the employer's actions. All right, the final case that we will be looking over is Bugiatis and Manji. So this is a little bit different because the employer is the plaintiff or one of the plaintiffs, and the former employee is the defendant. So the former employee was employed for about 3 years and managed key clients of the employer, such as Apple and Best Buy. He was terminated without cause, he signed a release, and he was given a severance package. However, after his termination, he began a campaign of harassment against his former supervisor and as well downloaded his employer's confidential data and sent disparaging messages to their clients. Misconduct continued to escalate despite cease and desist letters, police warnings, and court orders. So main issues here are whether or not the plaintiffs, which are the employers as well as the supervisor in this case, are entitled to an interlocutory injunction, which is effectively a temporary court order to restrain Manji from harassing the former supervisor and misusing confidential information. Another issue was whether or not they were entitled to an Anton Pillar order requiring the seizure and deletion of CleanMarks data from Manji's devices. So an Anton Pillar order is basically a civil search warrant, which permits a party to enter the premises of another without prior warning and seize evidence. It is quite a high threshold, requires the party seeking it to demonstrate a strong case, show serious damage, provide convincing evidence that the defendant has incriminating items in their possession, and show a real possibility that the defendant may destroy the evidence. And then the final issue is whether or not elevated costs should be awarded. Right, so the employer argued that the employee downloaded confidential information and used it to harass and defame them. They submitted that the criteria for both the interlocutory injunction as well as the Anton Pillar order were met. The employee disagreed. He admitted that he retained data and contacted clients, but denied that he was harassing them and claimed instead he was acting as a whistleblower. He also claimed that the Anton Pillar order was an unreasonable invasion of his privacy and violated his charter rights. Ultimately, the court decided to grant the interlocutory injunction and Anton Pillar order and decided that all the factors were met as described below. And as a result, Manji was ordered to return and delete all confidential information, stop harassing his former supervisor, and to surrender his laptop and other devices. And the court found that the charter did not apply in this case because there was no state action. It was just between private parties. And he was also awarded costs on a substantial indemnity basis due to Manji's conduct. So this is a step up from the typical cost award, which is partial indemnity, which represents approximately 40 to 60% of the successful party's costs, while substantial maybe anywhere from like 75% to 90%. All right, so why is this important? Basically, it shows that employers do have powerful remedies available to them if their employees breach their post-employment obligations, including confidentiality and non-disparagement clauses, as well as the fact that elevated costs are available to sanction a party's misconduct. All right, so the next topic we are going to discuss are recent amendments to the Human Rights Tribunal of Ontario procedure and the Employment Standards Act. All right, so briefly speaking, the HRTO is the administrative tribunal that enforces the Ontario Human Rights Code and has jurisdiction over discrimination and harassment based on protected grounds under the code. So one of the biggest changes is that on June 1st, 2025, all applications are now subject to mandatory mediation. So this change does not apply retroactively. Any applications filed prior to June 1st aren't going to be impacted. And previously, all mediations at the HRTO were voluntary and both parties had to agree to participate. So mandatory mediation isn't a new thing in litigation. It's already mandatory for all civil litigation matters that are commenced in Toronto, Windsor, and Ottawa. Those ones particularly have certain procedural requirements in that they must take place within about 6 months after the defense is filed. Right. So just a little bit about mediation procedure at the HRTO. So mediations are free and the parties are not required to have legal representation, although we of course recommend that you do. Mediations are held over video conference and are typically scheduled for about half a day or 3 hours. A member of the Human Rights Tribunal will act as the mediator, and they will not make a determination of the dispute. They will not, if the mediation is unsuccessful, they will not participate in the hearing. They are mainly there to attempt to help parties work toward a mutual resolution. So all parties are also required to agree to confidentiality terms. These are typically it's just a verbal agreement, basically that all information disclosed during the mediation is confidential, and the parties cannot later rely on the statements made if the matter doesn't settle at a hearing as evidence. So mediations are often highly successful in the HRTO and often result in resolutions. And again, the vast majority of cases settle and they do not proceed to a hearing. However, if your matter doesn't settle at mediation, the next step will be the HRTO scheduling a hearing. So what happens if someone fails to attend, as these mediations are now mandatory? So if you are the applicant, your application may be dismissed altogether. If you are the respondent, your application may proceed without further notice to you, and you may lose your right to participate in the proceeding. As well as in both cases, the HRTO is entitled to take any action that they deem to be appropriate. So even though mediations are mandatory, parties are able to request an exception in exceptional circumstances. It's not quite clear what those exceptional circumstances are, but all requests must be made at least 77 days prior to the mediation date itself. So what does this mean for employers? It might mean that if you are represented by legal counsel, you now have to factor in the cost of a mandatory mediation, as well as you may have to disclose key documents earlier in the process to facilitate settlement discussions. Another procedural change is that several forms from the HRTO have been updated. As of June 15th, all filings with the previous versions will be rejected. All right, so now on to amendments to the Employment Standards Act. One of the amendments is the introduction of the long-term illness leave. So this leave is effective, or was effective, as of June 19th. The requirements is that the employee must have been employed for at least 13 consecutive weeks. The employee will not be performing their essential duties because of a serious medical condition. And there's no definition of a serious medical condition, but the Act clarifies that it includes a condition that is chronic or episodic. And then the final one is that a qualified health practitioner must issue a certificate stating that the employee has a serious medical condition and setting out a period that the employee can't work because of that condition. Maximum entitlement for this leave is 27 weeks in a 52-week period, and employers must retain their records for 3 years after the day on which the long-term illness leave expired. All right, so another amendment is that employers are now required to provide additional information to new employees. This came into effect on July 1st. So employers must provide the following information to their new employees, either prior to the first day of work or as soon as possible thereafter. So this required information includes the employer's legal name and any operating or business name that they have, contact information for the employer, including any address, telephone number, and a contact name, a general description of where they will be working, their starting hourly or other wage rate, and any commission if applicable, their pay period and pay date, as well as a general description of their initial anticipated hours of work. So this requirement only applies to employers with 25 or more employees. So if you don't have 25 employees, you don't have to worry about this. What can employers do to satisfy this new requirement? Could include adding the required information into the employee's employment contracts themselves or any welcome packages, and ensuring that their HR departments are aware and kept up to date of these new requirements. Right, another update from the ESA is the creation of the Digital Platform Workers' Rights Act. So this came into force on July 1st. So it applies to gig workers as well as those working through app-based digital platforms such as ride sharing and food delivery. This might include Uber, Skip the Dishes, Lyft, those sort of organizations. Previously, all of these workers were not covered by the ESA, and they did not have the same protections that more traditional employees did. And then operators are defined as a person who basically facilitates and permits the workers to access and use the digital platform. All right, some key provisions in the this act are that workers are now entitled to the minimum wage rate under the ESA, excluding tips and other gratuities. They now must have a recurring pay period and set payday, and all pay must be provided by or pursuant to the pay period and payday. Operators cannot withhold or deduct a worker's tips or other gratuities unless they are authorized to do so by the Act. They also must disclose certain information to workers, including information related to how their pay is calculated, their tips, performance ratings, and work assignments. Operators also cannot remove a worker's access to the digital platform without a written explanation. And in most cases, they must also provide 2 weeks of written notice, though this may change if the worker was found to be, their access was found to be revoked for cause, which again is defined in the Act itself. It also states that all worker and operator disputes must be resolved in Ontario, and this likely is a reference to the Uber Technologies and Heller case, which was a major employment case from a few years ago that went up to the Supreme Court of Canada, which ultimately found that a contractual clause in Uber drivers' contracts that required them to settle all disputes through arbitration in the Netherlands was unenforceable, basically because it was cost prohibitive and didn't really permit the workers to raise any disputes with their employer. So this act now sets out in legislation that all the disputes must be resolved in Ontario. Workers are also protected from reprisal for inquiring about or exercising their rights under the Act. This is similar to the ESA. They cannot contract out of the Act or to provide a lesser benefit than to the workers as is provided for in the Act. Again, very similar to the ESA. And operators must retain workers' information for 3 years after the worker's access to the digital platform is terminated. All right, so I'm going to now hand it back over to Marty, and he is going to discuss what employers might expect in 2026.
Okay. Thank you, Leslie. So our last topic here is, as Leslie has mentioned, what can employers expect in 2026? So we'll go through a few of the expected developments here. So there is a leave which will come into force at some point in 2026, most likely, which is called placement of child leave. So this leave applies if the employee has been employed for at least 13 weeks and a child has been placed into an employee's custody, care, and control for the first time for the purposes of adoption, or if a child arrives in an employee's custody, care, and control for the first time where the person who gave birth to the child was a surrogate. This leave can begin up to 6 weeks prior to the expected date of the placement, and the maximum length of this leave would be 16 weeks. And employers must retain records for 3 years after the day on which the placement of child leave expired. The next expectation, or what we expect is going to happen for employers, is about cleanliness in washroom facilities. And this is going to be an amendment to the OHSA, the Occupational Health and Safety Act. So as of July 1st of 2025, the OHSA already required employers to maintain their washroom facilities in a clean and sanitary condition and to keep written records available. Now, as of January 1st of 2026, the records or the cleaning records need to be posted either somewhere obvious near the washrooms where the employees can see them, or electronically where they can be accessed. There are also some requirements coming into force on January 1st of 2026 for publicly advertised job postings. So the rules apply to employers with at least 25 employees, okay? And the job ad in question must meet the definition of a publicly advertised job postings. So to be clear, this would not include a general recruitment campaign that does not advertise for a specific position. It doesn't include a general help wanted sign. It does not include postings that are available only to current employees. And this is an Ontario statute, so essentially it's not going to include postings that are not related to Ontario. So what are the requirements if your job posting is caught by these requirements? So number one, the expected compensation needs to be posted, and the range cannot exceed $50,000 unless the range exceeds or ends at $200,000. Okay. It is prohibited for employers to put on their ads that Canadian experience is required. Any use of artificial intelligence, AI, needs to be disclosed. Okay. So any assistance involving the screening, assessing, and the selection of the applicants, and the employer must also disclose whether the position is for an existing vacancy. There is also a requirement to inform any candidates that were interviewed about the result. So essentially, the employer must inform all applicants who are interviewed whether a hiring decision has been made within 45 days of the interview. So effectively, you have to get back to the candidate within 45 days as to whether or not they are going to be hired. And this can be communicated either in person, in writing, or through other forms of technology. And there is now a new obligation for employers to keep records. The copies of the job postings, applications, and interview information need to be kept for 3 years. A little bit more on AI in the hiring and recruitment process. So as we mentioned already, there is going to be a requirement for employers as of January 1st of 2026 to disclose the use of AI in the hiring process. So let's look at, some of the implications, some of the things that employers need to watch out for. So it's very important to consider how the AI is making its decisions. So what data is it relying on, and whether it is incorporating any form of unintentional implicit bias into its decision making. So for instance, if you're using an AI tool to screen resumes, and for whatever reason, the AI tool is giving preference to candidates with male names over candidates with female names, that is a problem. And if the candidates suspect that something is up, that could result in human rights complaints against the employer. So if for employers who are going to be using AI tools in the recruitment process, you need to be very, very careful as to how your AI is making its decisions. It needs to be in compliance with the ESA and the Human Rights Code and other employment statutes. And AI tools absolutely need to remain subject to human oversight, or else you're not going to know if there is a problem that could result in legal liability for an employer. More generally, about AI in the workplace, Most employers these days are likely using some form of AI. So if you're using GPT, Perplexity, Copilot, Alexi, Claude, there's a number of AI tools out there. For any employers who don't already have a policy which governs and addresses the use of AI tools, now is the time. Better late than never. Okay, policies should address the following and likely other issues. So, what is going to be considered an AI tool? What sorts of uses are permitted and restricted in the workplace? When should we be disclosing the use of AI to clients, to management, to our coworkers? Who is ultimately accountable for the information that the AI is providing? How do we protect client confidentiality and sensitive information? How do you make sure as an employer that your employees are not entering your company's confidential information and information belonging to your clients into chat GPT, where it's going to stay somewhere on their servers, right? How do we prevent that? What sort of training should be required on whatever AI tools the workplace is going to choose to implement? In the legal world, we have already seen some instances of over relying on AI and AI hallucinations. A hallucination is effectively when an AI tool spews back information that is essentially made up. We have seen cases where lawyers were relying on AI tools to come up with a case law in support of legal arguments they were making, and ChatGPT effectively just made up cases. Um, in some cases, asking the AI, whether or not the cases are real is not going to solve your problem, because in many cases the AI will double down and say, of course the cases are real. I would never, make up cases. So really, this just needs to be dealt with by human involvement, fact checking the information that is provided by the AI. There are many AI tools. Perplexity is one. The paid version of GPT as well will actually provide citations or websites so the user knows where the information is coming from. That's nice. My suggestion would be, even if you see a citation that appears to be a very reliable source, if you were going to rely on that answer that the AI tool is giving you, you need to go to that website and actually make sure that the website says the same thing that the AI tool is giving you. Because in my use of various AI tools, I have found that the sites or the links that the AI tool provides as references for the information, I have found that those sites don't always contain the information that the AI is saying that they do. Okay. On that note, we're going to take a break, okay, and we're going to review the questions that were submitted. So if you have any questions for either of us about any topics that we have covered so far, please feel free to post them in the Ask a Question feature in Zoom webinar, and then Leslie and I will answer as many as we can after the break. So we will see you back here for the Q&A period at 11:15. Thanks, everyone. Okay, so thank you all for your questions. Leslie and I have gone through them, and we've answered a bunch of them already in the Q&A part of Zoom webinar. We're now going to go through a few more and do our best to address them. So there was a question about the slides and will they be available? So just for everyone's benefit, the slides are now available. I did, in response to the question that we had about the slides, I've posted the link to the slides, so they are now all available for everyone. Um, if you would like to receive a copy by email, you are welcome to email either of us and request them, and we will happily email you a copy. But they are available on our firm's website. Okay, so just a few of the questions here. So there's a question that we haven't answered yet in writing about what happens if someone's illness extends beyond the ESA period. So I don't know for sure which leave we're referring to. I mean, there are a number of them, but essentially, if an employee is sick, they would be entitled to to certain leaves under the ESA. But I think the point that the question is getting at is, well, if there's an employee who's sick, if there's an employee who's sick and they are sick for longer, than the leave period provided by the ESA, well, then what happens, right? Well, the ESA leave period, I mean, is just the ESA period. But if an employer, or sorry, an employee, is unable to work for medical reasons, likely the way that it would play out is the employee would get a medical note from their doctor. The doctor would likely set out in a medical note that the employee, continues to be unable to work, and then the employee would continue on an unpaid leave. Okay. Leslie, did you want to add anything on that one?
No, I think that you covered everything
No.
quite well.
Okay. The next one that we'll look at is a question about the expected washroom cleanliness standards, and then the requirement to post the records. The question is, if you're a tenant in the office and there's a shared common washroom with the other tenants, um, do the tenant employers, are they ultimately responsible for this, or can the obligation be somehow passed along to the landlords? So I mean, if the depends on the specific situation, but I mean, if the reality is you've got cleaning staff in the building and they are going to be the ones who are doing the cleaning, I would say that certainly, I mean, it's a good discussion to have with the cleaning staff to make sure that they keep the records. But ultimately, the obligation is going to be on the employers to make sure that the records are available. So I think a level of collaboration is going to be needed with the landlord and possibly the cleaning staff to make sure that the right records are available and that they're going to be posted either by the washrooms or electronically. So certainly an opportunity for collaboration there. Um, there is a question here about is it still worth going to court for at any time termination clauses when the employer refuses to negotiate, assuming that is the the only the issue. Well, I mean, I'm not sure which side we're asking from, but if I mean the state of the law right now, I mean there is some ambiguity because we looked at the Dufo case, which was upheld on appeal, which I think does make it pretty clear that if there's a termination provision with that language, it's not going to be enforceable. So again, that's the, at any time language. There is the one case that we talked about, the Lee decision that is under appeal that essentially came to a different conclusion. So, I mean, technically right now, I mean, there is an argument, to be made that, there is some sort of, ambiguity in the law, which, at least from the employee's perspective, I mean, maybe it does make sense, to take a run at the employer. But again, just don't forget that the Lee decision is under appeal. And if we go back to the first presentation with all of the cases that we looked at from 2025, most of them do tend to follow Dufo because Dufo was decided and it was upheld on an appeal. Now, at the Court of Appeal, they didn't actually address the at any time issue, but the case was upheld, right? So it's still good law. Um, so hopefully that addresses the question, regardless of which side we're on here. Okay. Um, let's just take another look here. There's a question here about the maintenance of records. So presumably all the job applications that hiring platforms like LinkedIn, Indeed, and so on would have to uphold. So I mean, the requirement is for employers, right? Um, so I mean, I think what the question's getting at is if you're an employer and you have posted a job on LinkedIn or Indeed, and you've got all these resumes coming in, is there a way, or might there be an obligation on the part of LinkedIn or Indeed, to keep those records? And I mean, I don't know exactly what those sites are going to do. I mean, this is a specific law that's going to come into to effect in Ontario, and of course, LinkedIn and Indeed operate all over the place. So I mean, there may be some tools that you can use in LinkedIn and Indeed and other similar sites to help. But ultimately, the way it's drafted, that is going to be the employer's responsibility. So ideally, employers should figure out a way to just get all the resumes somewhere onto their server, and then just keep them for 3 years. Okay. So I think we have now answered all the questions. So thank you again for your questions. If you have any other questions that you think of, feel free to email us. So just quickly, in uh, in conclusion, thank you all for coming today. And then again, there's the question about slides. So again, the slides are available. They have been made available online. We sent you the link, so feel free to access them. Um, Please remember that nothing that we have said today should be taken as legal advice. We're here to help and provide legal information, but please don't take anything that we've said today as legal advice. If you need legal advice, we're happy to help with that. Please get in touch with one of us, and we will happily give you the legal advice that you need. Um, if you have any feedback about the topics or the seminar, please feel free to pass it along to us or to our marketing group. If there are any topics in particular that you would like to hear us speak about in the future, let us know, and we'll certainly take that into consideration. We try and do these seminars once a quarter, so roughly every 3 months. We haven't yet scheduled the next one. but likely it will be in December of 2025 later this year. Okay. Um, did I forget a question? Did we forget a question, Leslie?
Yeah, there was just another question added to the chat at 11:22. What if an employee refused to sign an agreement? Can you retract the offer without making concessions? What if they're an existing employee and don't want to sign an updated agreement?
Okay, well that's a bit of a loaded question here. Um, I mean, just generally, I mean, if we look at principles of offer and acceptance, I mean, if an offer is presented and the employee has not yet signed it, the employer in theory could, well, not in theory, I mean, could say, well, the offer's revoked, so we've changed our mind and we're not going to give you that raise. Depending on the circumstances, I mean, the employer does have a duty to act in good faith. So, I mean, the employer should consider whether withdrawing it, would amount to good faith or bad faith. And we can help you with that as lawyers. And the second part of the question says, what if they're an existing employee and don't want, okay, well, if there's an existing employee who already has a contract or already has established terms of employment, and the employer says, okay, well, here's a new contract, and I don't know, maybe the new contract says, okay, in exchange for a raise, you have to agree to a different termination provision, and the employee says, well, I'm not signing that. Well, I mean, the employment would continue under the current terms, and if the if the employee was unhappy with that, um, then uh, then the employer would have the option of terminating the employment. Okay. All right. On that note, thanks everyone. Thanks for coming again. Thanks for your questions, and have a great day. Goodbye.